Hi, everyone. It's so nice to see you. I see some familiar names. So thank you for joining us for our next Jay at Home series. I am Allison Kierman. And what I want to talk to you about today is a second part of estate planning, which is what to do after you have lost a loved one. So I typically I do estate planning and probate. And what that means in its simplest terms is I help people get organized during life with their wills and trust and financial and medical powers of attorney. But then I also help people after the loss of the loved one. And this is everything from how to interpret the estate plans a family member may have had, to addressing what happens when there aren't plans, or the plans can't be found, or the plans are incomplete. And we're going to talk about that second part today, because if you've experienced a loved one, if you lost a parent, I'm sorry, and it may have been more difficult than you were expecting. And if you haven't been through the process yet, I think it's important to be armed and just sort of understand what will be asked of you. And then if you can, start the conversation with the loved one about where information is and what their wishes are. It will definitely be easier for you the more information you know going into the situation. So the things we're going to talk about today, our agenda is first, trust or estate administration. Then we're going to talk about probate. And then we're going to have a fun conversation about contests, so litigation when people start fighting. If you have a question at any point in time, please feel free to send me notes in the chat, and I will try my best to answer your question. So one of the reasons why we get organized is because after something has happened, it's too late. And even sometimes before the loss of a loved one, once someone has become incapacitated or they cannot sign documents, it is often too late to make a plan. And if you haven't discussed the plan with your family, it may lead to a lot of confusion. So I really like my job because it is super interesting and I get to hear everyone's stories. I also read a lot about other people's stories. So some of you may remember Anna Nicole Smith. She was a famous Guess jeans model. I remember looking at her pictures in magazines when I was in a younger girl. She was a model, she was a Playboy playmate, and she was a stripper. And there's no judgment at this office at any time. At one point in time, she met a man while she was working. She divorced her husband, and she and the man that she met at a strip club got married. There was a very large age difference between them. So her husband, the older man, he passed away. And when he passed away, she inherited over $1 billion in Texas oil and land interests. Well, this is oil tycoon J. Howard Marshall. His son was not pleased at the loss of the inheritance to a stripper younger than he was. So they went to court. And they went to court in Texas local court. And then they went to Texas appellate court. And they went to the Supreme Court. And every court decision flip-flopped the other, such that they battled it out for more than a decade on who was going to inherit what. So at the end of the day, Anna Nicole Smith, she did lose. That the inheritance went to Marshall's son. But the really sad thing is that after they finished the court battle, the son passed away, and she inherited it anyways. She moved to the Bahamas, put all the money in foreign investments, and then she died without an estate plan. So now they're back in court yet again. So it's really interesting. No matter what you do, you might not be able to avoid the fight, but if you know one is coming, we really have to make sure that everyone is on board and that you get things done correctly. Also, you might consider not marrying a 26-year-old stripper. That's advice, but again, there's no judgment. Estate administration. So after the loss of a loved one, if they're organized, and even if they're not, the first question I get is, what do I do now? That's a hard question. So usually it is emotional at an emotional time. It could be before or after the funeral. And often the question is precipitated by someone in the family saying, when am I getting my money? So the answer is pause. I'm going to let you know, because that's a rude question. But aside from that, the first thing that I tell clients is take a moment to grieve. You have to plan the funeral. If the funeral is not already planned, that can be a really emotional time. You need a chance to figure out what's going on, what you want, and what is being asked of you. The second thing we talk about doing is start just collecting information. That is going to be the single most important thing you do in the beginning, is start to compile a list of everything that you know. What are the bills that you have to pay? What is the mail that you need to collect? And what are pressing matters, right? So some things have to be done within 30 days after passing, right? The mortgage, for example, depending upon time of year, the taxes. And so let's think about those priority lists and get those things wrapped up. The third thing we like to do is we want to make sure that we are turning off anything that doesn't need to be turned on anymore, and we're paying final expenses. So this is call the cable company, call the water company, call the electric company. Who is it that you need to contact to make sure that you're not continuing to spend money that doesn't need to be spent? And if you have real estate, for example, and you need to leave the air conditioning and the lights on, let's do that. But let's see if we can negotiate down the bill to something that's going to be reasonable so that you're only paying for expenses you actually need. Whether the estate is very well organized or not, this is always your first steps. Collecting information, canceling bills, and paying the last set of expenses. So the next thing we have to do is start making phone calls. And this is where we want to contact all the benefits providers or other asset holders. This is Social Security, Veterans Affairs, the Department of Health, the Department of Motor Vehicles, the Registrar of Voters, your life insurance company, the pension plan. It could be the last employer. Everyone that you can think of that might hold assets from the person that's passed needs to be contacted. And they need to be contacted because you need to understand what assets exist. This is important so you can pay the bills that need to be done, but also so you can start to understand what is sort of the lump sum of assets that exist and how is it to be distributed. And you'll find that once you start making phone calls, a whole bunch of more questions will arise. So you reach out to the life insurance company and they tell you there's a beneficiary on the account. Great, that's a good organizational tool. But the beneficiary may not be who you expected, and it may not be the person who's paying the bills. So that can lead to further conversations about if the only money exists is with a beneficiary, then you as the executor, the administrator, have to figure out how to proceed next. But every person you call is going to want mostly a death certificate and proof that you are the responsible party. So a will naming you the executor is really going to be helpful. The next thing we talk about doing is inventorying assets. So we want to know, as part of the benefits, what is in the bank, brokerage statements, stocks and bonds, any corporate assets that you may have, deeds for real estate, deeds for the boat, and the jewelry that you have. Is there a safe or a safe deposit box? What is sort of the total of tangible and monetary assets that exist? It can be important for you to understand if the individual who's passed left what I think of as a personal property memorandum. So did they leave a list of who gets what? And I mean that in terms of tangible items. Who gets the wedding rings, the watches, grandmother's china? These things could be expensive. They could be family heirlooms. They could be donation quality. But you have to make sure that you understand what all the physical items are. If there is a note about who is to receive them, and you have to make sure you do not throw them out. So do not distribute them to the wrong person and do not get rid of them. There may be exceptions to that, which is why people call lawyers, right? So the exception is you have to sell the wedding rings in order to pay for the last set of expenses. Maybe that's allowed, but that is part of a bigger conversation, and you don't want to do anything prematurely because once you've sold the wedding rings, it's too late to get them back. So if someone is supposed to receive them and they're mad at you, you might have a problem, both legally and emotionally. So after you have an understanding of the assets and the bills, we need to figure out how you're paying accounts. And that is literally you have to set up a bank account. It could be in the name of the estate. So for example, the estate of Allison Kierman would have a bank account. If the individual had a trust account, then you're already ahead of the game. And you can use the trust account that is created. And it's from either the estate or the trust accounts that you're writing checks and paying bills. That could be online or again through the check process. But you want to make sure that you're doing everything properly. And this is part of keeping a detailed accounting. So you need a list of all the bills you're paying, from what account it was being paid, and then at the end of the day, we have a total of what's left and how it's going to be distributed. The detailed accounting can also include your time. So some estate plans allow for you to be reimbursed for expenses you've advanced, but also to be compensated for your time. And you're going to want to take note of what that is. And then at the end of the day, we have to identify who the beneficiaries are. So you need to review the estate plans and take into account who is to receive what. If there are estate plans in place, there also are probably plans for when and how the beneficiaries can inherit. So you can't send the granddaughter a $50,000 check if the trust says granddaughter doesn't receive that money until she finishes school. Even if you think she needs the money to pay for school, if the plans say something else, you cannot act contrary to them without having a legal ramification. So you need to be clear in understanding who gets what, when, and how. You also have to let the beneficiaries know. So there are statutory obligations that say you are to advise, I have been appointed executor or the trustee of the trust. These are the documents that exist. Please let me know if you need a copy. And this is what I believe you stand to inherit. Full disclosure and transparency is legally required. You may not like it, but again, that's why sometimes people have a lawyer act as the intermediary, but it is required of you. And then the last thing you have to do is make sure you file for taxes. You don't always have to pay, but you're always supposed to file. And in particular, there's a filing after someone's passed that you have to do. So these are what I like to think of as the 9 common steps for estate and trust administration. For any client or family member of a client who lets me know that someone has passed, I send them this list, in a more detailed way, and we talk through the process and walk through the process. So if you've done this before, it can be easy for me to give you a list of steps, but it can take many months to actually go through the steps, right? Calling Dish to cancel the cable contract could take you 5 phone calls and make you want to quit. So the thing is for you to know that you are not rushed. Under the law, you have 2 years to close the estate of someone who has passed. So just because someone has come to the funeral and say, when am I getting my money? Doesn't mean they're getting it right now. You have 2 years to complete the process. This also means, though, if you believe you're the beneficiary of an estate, you may have to wait for 2 years. So you have to be careful not to spend the money before you actually receive it. So the next thing we talk about is probate. So estate and trust administration is something that usually happens without the court system and a court process. There will be times when you realize you have to go to the court to get permission. So probate is the legal process for distributing assets after the loss of a loved one. There are things that individuals can do to avoid probate. Probate avoidance tools include beneficiary designations. That's for accounts, for real estate, for cars. And you can also get probate avoidance through a trust. So if assets are properly titled in the name of a trust. What I see a lot of, unfortunately, is people who are like, well, mom paid $5,000 for a trust, why do I still have to go through probate? And that is when issues arise. So you have a beneficiary designation, but it's an improper designation. So in a case last year, the 2 sons, after dad passed, there was beneficiary designation on the financial account. It was valued at more than $200,000. So really worth it for them to figure out how to get the money. But the current holder, the current broker of the account, said that the beneficiary form was improperly filled out. So the children had to go through probate in order to handle that because the form was incorrect. And I see incorrect forms a fair amount. So I always like to say, if you're not going to do a trust and you're going to rely on beneficiary designations, you have to really QC those to make sure that they're done properly and keep checking. Because after you've passed, it's kind of too late to get more organized. So probate has a bad name. I think it has a bad name because it can be expensive and time consuming. It's not confidential, and it is a burden for people who are feeling emotional. I handle probate. I try to do it as simply as possible for my clients, but it does require you to, for the most part, get an attorney. And if you don't get an attorney, to go to court yourself. So for people who aren't as comfortable with that, You need to make sure that you're doing what you can to be prepared. So what happens in probate? You have to file a will if there is one with the court. The will becomes public. Your nosy Nelly neighbor now can have a copy of your will for any reason, just because they're nosy. Some people don't like that. In particular, people who are very private or think that they have, personal confidential information. You see celebrities. This is how we know so much about celebrities' plans. It's because they either didn't have planning or they had a will, and the will becomes public information. But there's a lot of other information that also becomes public and has to be filed with the court. This includes a list of all the assets at the time of passing. So it's literally a chart. The asset, the value, the encumbrance, and who the intended heir is. You might not want for that to be public. You have to file a list of your creditors. So everyone that you owed money to at the end of death. You have to file all the addresses and other contact information for your heirs and beneficiaries. So if you are the executor, you have to make that information public. And if you're the executor, you also have to disclose personal identifying information about your physical appearance. So when people come to my office, I have to ask them questions about how tall they are and how much they weigh. And they sort of look at me and frown. This is not what I'm looking for. The court needs this information so that if there's a question, they can physically identify you. So the downside of all of this becoming public is, aside from the fact that nosy people can look into your affairs, is it also means that creditors and other people start contacting heirs and you if you're the executor. So I have clients who are like, I got so much junk mail for people wanting to buy mom's house. And it's all because your information has now become confidential, and anyone who chooses to look up that information from the court system can. Creditors also have sort of software that runs through all the probates, and so they get that information just as a matter of fact, and then use that for their own purposes. So you might not like that. So try to do full disclosure. Probate costs typically more than $2,000. The filing of probate with the court system alone costs more than $500. As an executor, you have to file more than 15 court documents. These documents have to be notarized and need an original ink signature, which means that you have to meet essentially with me a couple of different times in order to make sure that things are done properly. The probate process takes at least 6 months. And this is because you have to give notice to the creditors, and creditors have 4 months to make their claim. So there's no way to shorten or expedite that process. It's a statutory minimum. In Arizona, probate is on the rise, which means that there has been even a greater delay in the process. So I can say it's going to take at least 6 months. Cases that are easy, we can typically wrap up within 9 months, but if there's ever an issue, so something is done improperly, the court has questions, or one of the heirs poses a dispute, you're looking at least 22 months. So we're really coming right under the 2-year deadline in order to get things handled. The good news is you got it handled, right? You still get the inheritance, things gets wrapped up. It's just a little bit more complicated than if a family member was more organized during lifetime. Will contests. So this is the Lifetime movie version of what I do. So the estate contest is if there's a lawsuit filed by a disgruntled family member, they either think that the will or the trust is invalid, or that it's interpreted incorrectly, or that the executor has done something incorrect. That's my least favorite. If you are the executor, that's going to be your least favorite, which is often why it's helpful to hire professional help so you don't make a mistake. Who can contest a will? So unfortunately, we live in a very open judicial process, which means we tend to be pretty litigious as a society. You need technically standing to be in probate court. So legal standing are those who are beneficiaries who are named in the will and trust. Previous beneficiaries, so the estate plan from the 1990s who named, your 2 cousins as heirs, they have a right to contest the will or the trust. And I see standing for individuals who are not named in the documents, but who believe they should have been or would have been, or who otherwise are natural heirs. So if you intend to disinherit a child, we need to state that affirmatively in your plan. Otherwise, they have a right to sue. So there are many legally valid reasons to contest a will. So it could be because the will or the trust is incomplete or faulty. The biggest thing I see is failure to properly execute it. So we have a form downloaded from the internet, mom and dad sign, except the rest of the information is not done correctly. So you need 2 witnesses, unrelated by blood or marriage, and a notary. And they need to sign in the presence of one another and in the presence of the person who signed. The second reason why we see contests is because the person who made the will is not of sound mind. So you can't wait until the very end. You can't wait till after there's an Alzheimer's or a dementia or an edema diagnosis. You have to be ahead of any physical or medical issue in order for things to be valid. The third thing, and what we see sort of in the media, is the person who made the will was coerced. So coercion could be from one of the children who has all of a sudden gotten more than the other. It could be to the second spouse who is all of a sudden inheriting. It could be from a caretaker, which we see unfortunately a fair amount of in Arizona. But it's someone who has exerted their influence to get more than potentially their fair share. And the last reason we see contests is that the will was unduly influenced. So someone who had was in a position of power made a change, and that they could have coerced into it. So I'm not going to let you live with me, or I'm not going to take care of you if you don't sign this document, or I'm not going to loan you $5,000 if you don't promise to pay it back and pay it back out of the estate. Those are the types of things where we see very valid will contests. So a will contest isn't always invalid, right? A lot of them are valid, which is why people go to court, but they extend that 2-year time frame for probate, and they extend the cost on the $2,000 estimate I gave you. So will contests are expensive and time consuming. They can also be emotionally upsetting. So you want to make sure to do the best you can that will contests are avoided. So I have sort of some horror stories in probate. This is what makes my job interesting that I wanted to share with you. So had a senior client. He wanted to change his will. The old will had an old girlfriend as executor. They no longer have a relationship, but he never comes in to finish signing the documents. So saying, I have a plan, but without having ink signatures on the paper, you have nothing. So before the plan is executed, client goes to California with his son. They're in an accident. He's in a coma. The son has no legal rights. There's no power of attorney. He can take no action without first securing emergency guardianship in the state of California. So he does that. We do his best to help him. Dad gets better. They come home. Then dad passes. This whole time, though, everything is going to the old girlfriend, and the old girlfriend is the executor. So the son now has spent time and money securing guardianship and wants to be paid back, if nothing else, but also wants his fair share of the estate. So if you have old documents, you need to make sure that you're updating them, and just calling an attorney is not enough. You have to actually sign the updated documents. So next one I see a fair amount of is the informal business owner. So you and your buddies got together, you have a great idea, maybe start in a garage, maybe start in a bar, wherever it is, you go in business. Business is great. The idea was great. Everybody gets along, you're making money, some people quit their jobs, but everyone is doing what they can to make the business grow. But the friends who started the business never took the time to formalize the business. So there are no documents identifying really who owns what happens if one of them passes, and there's no what we call a buy-sell agreement. So something that says that the other business owners have to buy out the spouse or the estate of the person who's passed. There's no formal documentation, but there's a will, and the will says everything goes to my wife. So the client is in a motorcycle accident and passes away. The wife, who wasn't otherwise working, she keeps all of his share in the business pursuant to the will. So the problem of this now is she a part of the business? Well, 3 guys did not go in business with their past partner's wife. She wasn't working before. She doesn't know the business. They don't think in her mind she's entitled to any share of the business, and certainly she doesn't have a say in how the business is run. The wife actually doesn't even want to be in the business either. She just wants the money from the business. The business may or may not be liquid. It's a question depending upon who you ask. So, because they only had a will, it goes to probate. So if you have a business and it's not formalized, the probate process freezes the business for all the business owners. So business is stopped throughout the duration of the probate process. In many cases, that means the business dies, because a business can't just stop doing business for 9 months and keep going on. This is much like we're happening right now. COVID closed everything down back in March, and for some people, they just didn't survive after that. So that can be a problem. The retired farmer. So I say that I naturally became an estate planner because I grew up with my grandparents on their farm and ranch. So I always love these types of stories. So the son grew up farming with his dad, and his dad said, "This will be yours. This is your legacy. We're working the land together. You love the land. It will be ours together after I pass." Well, mom passes away, and over time, dad remarries. When the dad remarried, he signed a new will saying everything would go to his new wife. He did not make an exclusion or exception for the farm. So after dad dies, the farm goes to new wife, even though son is working the farm. And son worked the farm while dad was sick. And if you know anything about farmland, you know you don't get income monthly the same way you get a regular job. You have to, sell the assets or market the crops in order to get paid. So the son has done all this work essentially for free. The new wife and her 3 daughters end up inheriting the farm. The new will prevails because the son had absolutely no rights. So I use this as a lesson, not just sort of for the dad, but for the son, which is if you believe you are getting a family inheritance, you need to know what the documents say, and that should be written down. Dad, I just want to make sure, fully supportive of you getting married and carrying on your life, but I just want to make sure that we're on the same page here about the farm. It can be a tough conversation to have. I have them at the Thanksgiving table every year when I go back to the farm, but those hard conversations will help you be prepared for the future. The interloper. The interloper story is my favorite. So I used to work at a big firm downtown. It was awesome. It wasn't great for life. So I started my own practice in 2017. And the first case that came to my door was this case. So mom passed away, then dad passes away. Dad has 2 daughters. One of them lives here, one of them lives in France. And as part of the administration process, the daughters discover dad's will and trust says that most everything he owns goes to another woman, someone they've never heard of, never mentioned to them, and they come to discover that the woman is married and she's of a completely different religion and ethnicity, which they felt very comfortable that their culture would not have allowed their father to have a relationship with this woman. So they come to me with all these questions. What can we do? Right? They want to sue. They want a will contest. They either think dad was out of his mind. This woman somehow took advantage of him or extrapolated a relation to him. Or at the end of the day, dad had an affair. Nobody knew, and new woman spouse didn't know. And he really intended for her to inherit everything because he loved her. The hard thing is that you can't ask questions to someone who's passed. So they don't know if dad acted intentionally or if he was taken advantage of. And if he acted intentionally, they have a lot of questions about this relationship that they'll never have answers to. So of course we go to court. It takes 17 months. We end up coming to a settlement. So they got something from the inheritance, but they did not get the answers to their questions. And it was really emotional for them to go through this process. They were deposed. The other woman was deposed. All of dad's friends were deposed. It was an upsetting time period for them and really stressful. So the key is, what do your documents say? What do your parents' documents say? Are you prepared for what comes next? So if you think, I want to make sure none of this happens to my family, there are things that you can employ in order to protect from will contests. And the biggest thing I see is do not do it yourself. I understand it can be cheaper. It is likely not less time consuming, and you cannot prevent against all the possible errors. At a minimum, at the end of the day, if you have a lawyer, they can testify on your behalf as to your wishes in order to avoid disputes. Aside from meeting with a lawyer, it is helpful to discuss your wishes with your family. I know they're hard conversations, and it might not be what your children want to hear. It might not be what you want to say or what you want to hear from your parents, but communication is the best way to know what's going to happen. I hear a lot of, this is what dad would have wanted. This is what dad told me. That wish is not a legal requirement, right? I can say the documents give you these rights, but the wish, the emotional feeling from the communication that you have with your loved ones is what will carry you through and carries a lot of weight. The third thing you can do is just keep your plan up to date. If you remarry, if your children remarry, if you have grandchildren, if your children get divorced, life events prompt changes in your plan, and it's always worth it to be up to date. Because you could think, well, I never would have done that if they got divorced. But if your documents don't say that, then it doesn't matter what you think. It only matters at the end of the day what you signed. And the best way to protect is to contact a professional. So as attorneys, I promise I have seen more of the drama than you have. Potentially have also watched more Lifetime movies than you have. And I can make sure that we're doing what we can in order to protect against problems from the future. If you want a copy of this PowerPoint or the 9 Steps of Trust and Estate Administration, send me an email. I'll send it to you. You don't have to wait till that happens to you. It's always helpful to be informed. And if you have questions, now is sort of the open forum time for you to share them. So tell me what's on your mind, what happened, what you heard, the movie you saw, and I'll do my best to give you an answer. So while you're thinking, I can tell you, it has been a rough week at the office. I had 3 different family members call me because they are facing end-of-life questions. The call I literally had right before this was a woman whose son has been on a ventilator since March 31st. She's like, what do I do? And the unfortunate thing is that she has no rights. Her son didn't sign anything giving her rights. She doesn't want to be responsible financially for any decisions. And so she had to give her the bad news, which is that unfortunately there isn't anything she could do. The doctor will talk to her. She should take advantage of that. She's in her right. And then for her own personal sake, she realized, she was like, well, she needs to update her plans because now her son can't inherit. And even if he were alive, all the money would just go to pay his medical bills. That's depressing. So for people who read the news, watch the news, it can be kind of sad out there right now. So I hope everyone is staying safe. And yeah, that's my PSA. Be careful. Thank you for joining us. It's always fun to share what I do. And if you do have questions, feel free to call or email. I meet with people, talk to people all day, every day. You can tell me a story, share a joke, and I'll do my best to give you advice.